Good morning, and thank you for your participation today. A warm welcome to those of you who are joining us in person, as well as to those of you who are joining us online. We acknowledge today that we are here on the original lands of the Anishinaabe, Innu, Dakota, and Dene peoples, as well as the homeland of the Red River Métis, and we acknowledge the harms and errors of the past and commit to moving forward in a spirit of reconciliation and collaboration. We're grateful this morning for this opportunity to come together with a panel of experts, Karyn Stone from the Red Cross, Nathan Derejko, who's the Mauro Chair here, and Kjell Anderson, Director of the Human Rights Program. I'll introduce them a little more fully in a moment, to talk about current conflicts and the limits of international humanitarian law. We're also grateful today to today's sponsor, which is the MLT Aikins Affiliation Lecture, which is a lecture that fosters dialogues related to peace and conflict studies. We're also grateful to the Mauro Center for Justice and Peace here at St. Paul's College, as well as the University of Manitoba Master of Human Rights Program, the Peace and Conflict Studies, and graduate programs. And we also note that I regret that our fourth panelist, Professor John Packers, is not able to join us today. He's ill. So conflicts, both present and past, accompanied by loss of human life, serious irremediable injury, destruction of property, cultural treasures, historic works, infrastructure, and damages to life-sustaining environments, provoke heated debates about right and wrong, about what can be done, what ought to be done, what responses are appropriate, best, correct. These subjects are both tragic, because they're precipitated obviously by terrible situations, and they're also deeply, deeply divisive. They're hard to talk about. Few of us can escape their reach. Some of these conflicts touch us personally, the loss of family members, friends, and community. Some of us are touched by the images that are streamed online and the stories that are brought right into our homes, right onto our computer screens. Suffering of all description is visible for all of us who choose to see it. Law shapes social and political discourse, as well as to a certain extent factual discourse. International humanitarian law, which we're going to talk about today, is part of the legal structure that colors conflict, that can frame debates about right and wrong, about claims to justice, about claims about responsibility and accountability. Law is neither perfect, nor is it necessarily effective. But nor is the law project, whatever that might be, ever complete. And some would argue it's been at a standstill for many years, not only international humanitarian law, but also other areas of law. So this morning, in hosting this discussion, and hope to contribute towards connecting international humanitarian law and its limitations to current conflicts. In partial, we aspire perhaps, if we don't offer glimmers of hope and of light, maybe it'll simply help us to think about and maybe to do some of the work that needs to be done, or even to think about what we might be doing to lead to perhaps maybe a different tomorrow. So through a respectful dialogue today, we would strive to both educate, to inform, and to enhance our collective understandings about the limits of international humanitarian law, the existent challenges, and some of the current conflicts. So we have about 90 minutes today. The format we're going to use is we'd like to hear from each of our speakers, and then we will allow for exchange, sort of a panel discussion, exchange amongst and between our speakers. And then towards the end, we would hope to invite our participants, those of you who are here present, as well as those who are joining us online. We would like to have some time to entertain any questions or concerns you might have. So let me begin, and also note that for everyone to note, today's discussion is being recorded. So let me briefly begin by introducing our speakers. We're really pleased to have all of them here today. Pleased to have on my right Mrs. Karyn Stone, who's the International Humanitarian Law Coordinator for the Canadian Red Cross, the Western region. Her expertise captures international humanitarian law, and she also has she brings considerable experience in actually working with that on the ground, seeing things through and through that lens. This would include, you'd be familiar with Médecins Sans Frontières, who work in a lot of different conflict zones. Some of the work in Nigeria, consultations in relation to Myanmar, and in other parts of the globe. So she brings this expertise to us today. On my left, we have Nathan Derejko, who is the Mauro Chair in Human Rights and Social Justice. He's also a professor in the Faculty of Law here at the university. His expertise covers in international human rights law, international humanitarian law, collective security, and the use of force. He works with and continues to work with humanitarian human rights law organizations around the globe, and some of his research has been referenced by bodies such as the International Committee of the Red Cross. On my far right, we have Kjell Anderson. He joins us. He's the director of the Master of Human Rights program here. He's also a professor in the Faculty of Law. His expertise extends to human rights, transitional justice, international criminal law, and his experience also includes roles working sort of practically, you might say, on the ground, roles with entities such as the Special Court for Sierra Leone and the Inter-American Commission on Human Rights. So all told, you will see, I refer you to online, their accomplishments and their pedigrees are there. I refer you to those. But you can see how their collective expertise is exceptional and is greatly welcomed. We're greatly welcomed today. So on that note, we will turn to Karyn Stone. We'll start off today's discussion. Begin to talk, maybe to ask us, or what are some of the frameworks of international humanitarian law?
Thank you so much for the introduction, and thank you to my fellow panelists, and thank you to everyone who's here in the room as well as those joining online. I'm really pleased to be here today. The topic, the limits of international humanitarian law in current conflicts, is one of great importance. I'm going to kind of start the conversation to talk a little bit about the importance of international humanitarian law compliance in situations of conflict, and then the significance of this body of law within the Red Cross and Red Crescent humanitarian movement, and then mention a few of the contemporary challenges that we're seeing sort of from a humanitarian lens. So international humanitarian law, or IHL, I'm just going to say IHL to shorten it in the discussion, provides a set of rules and principles that govern the conduct of armed conflict, aiming to protect those who are not or no longer participating in hostilities. It also regulates the means and methods of war. It outlines the responsibilities of parties involved in conflicts. This includes states and non-state actors. Now, IHL, this body of law, is deeply embedded into the DNA of the Canadian Red Cross, which is where I work, but also the wider Red Cross and Red Crescent movement. Our humanitarian movement has historical roots in responding to the humanitarian needs arising from armed conflict, and its origins actually trace back to the efforts of someone named Henri Dunant, who witnessed the suffering of wounded soldiers during the Battle of Solferino in 1859, and subsequently advocated for the establishment of international rules to protect and assist victims of armed conflict. This led to the adoption of the first Geneva Convention in 1864 and the formalization of the International Committee of the Red Cross. So the motivation that prompted the first Geneva Convention, and which later led to the updated conventions that we know from 1949, was the exact same motivation that led to the founding of the Red Cross. The Red Cross and Red Crescent movement, including the Canadian Red Cross, play a crucial role in advocating for the importance of IHL and promoting compliance with its provisions. Through our work, we raise awareness about the humanitarian consequences of armed conflict, including the consequences of violations of IHL, and encourage respect for these rules among state and non-state actors who are parties to conflict. We consider the promotion of IHL principles as central to our humanitarian mandate, and we do this through activities like dissemination of information, training programs, and advocacy efforts. IHL compliance is critically important to the Red Cross, Red Crescent movement for several reasons. Well, it emphasizes the protection of civilians and non-combatants during armed conflict. So it ensures that civilians, wounded soldiers, prisoners of war, and other protected persons are treated humanely. It establishes clear rules governing the conduct of parties to a conflict, minimizing the risk of harm to non-combatants, and ensuring that those who are wounded or captured are treated with dignity and respect. This aligns closely with our mission, with the mission of the Canadian Red Cross, the mission of the Red Cross Red Crescent movement to alleviate human suffering, including the suffering of people affected by war. Within the IHL legal framework, there are provisions that allow the Red Cross and Red Crescent movement and other humanitarian organizations to operate during armed conflict. So adherence to IHL provisions can help the Red Cross gain access to conflict-affected areas and negotiate for the safe passage of life-saving humanitarian assistance. Compliance with IHL by all parties to conflict enhances the safety and security of Red Cross personnel, so volunteers and staff, and it helps ensure the effectiveness of our operations. And by establishing safeguards for humanitarian personnel and assets, so things like medical supplies, it enables us to reach communities that are in need and bring life-saving assistance like food, shelter, medical care. Now, despite the importance of IHL in humanitarian settings, we are confronted with contemporary challenges that threaten its relevance and efficacy. From the deliberate targeting of healthcare facilities and personnel to the use of indiscriminate weapons in populated areas, violations of IHL continue to exact a devastating toll on civilians and non-combatants. Despite the existence of IHL treaties, we continue to hear about failures to comply and widespread violations of the law by both state and non-state actors. Ensuring accountability for violations remains a significant challenge, despite efforts to promote justice and accountability. A few challenges that I see with regard to IHL and contemporary armed conflicts, I'd like to highlight a few of these. The first is urban warfare. So the increasing prevalence of conflicts in urban areas presents unique challenges for IHL and often leads to severe humanitarian consequences due to its impact on civilian populations and infrastructure. So some of these consequences may include an increased risk of civilian casualties due to the close proximity between combatants and civilians. Civilians may be caught in the crossfire or targeted intentionally. They may suffer collateral damage from airstrikes, shelling, or ground combat. Conflict in urban areas often forces large numbers of civilians to flee their homes in search of safety. And finding safe shelter in heavily populated areas can be very difficult and challenging. War in cities also frequently results in significant damage to critical infrastructure. So things like schools, hospitals, water and sanitation systems, city electrical power grids. This damage can have real long-lasting effects on the delivery of essential services and the ability of communities to recover even after a conflict ends. Fighting in cities or urban areas can also impede humanitarian access, making it difficult for aid to reach people who need it. And urban environments can also become littered with unexploded ordnance and improvised explosive devices. Even after a conflict ends, these can pose a significant risk to returning civilians, and especially children are at risk. The second significant challenge that I want to highlight is related to new technologies. So the emergence of new technologies, so things like autonomous weapon systems or cyber warfare, present new challenges to the application and enforcement of IHL. So some people may argue that the rapid evolution of technology has led to some ambiguities in the law itself regarding the application of the existing rules. So new technologies may blur the lines between who's a combatant and who's a civilian, making it increasingly difficult to uphold principle of distinction, the principle of proportionality, these things that are really at the heart of what IHL is. Under IHL, new weapons or any methods of war must be capable of distinguishing between combatants and civilians, limit collateral damage, and only be used when necessary to achieve legitimate military objectives. And any new technological advancements must only be should be assessed for their potential humanitarian impact. And the development and use of certain technologies may require new or updated regulatory frameworks to ensure compliance with the law. As well as mechanisms for accountability and oversight must be established to monitor the use of new technologies and hold perpetrators responsible for violations of IHL. The third challenge to IHL I'm going to mention is the diminishing scope for humanitarian actors to operate effectively and safely in conflict-affected areas. So in today's armed conflicts, we're seeing many troubling trends, including the deliberate targeting of healthcare or humanitarian workers, attacks on aid convoys, and even the taking over of humanitarian facilities by armed actors in some cases. These all contribute to heightened security concerns and limit the ability of humanitarian organizations to reach vulnerable populations. Furthermore, conflict dynamics may impede humanitarian access to affected areas, either due to deliberate obstruction or because of logistical challenges or the imposition of bureaucratic hurdles. So access restrictions that prevent neutral and impartial humanitarian organizations prevent us from delivering life-saving assistance, conduct needs assessments, and really monitor the humanitarian situation effectively. In some conflict settings, humanitarian work or aid is sometimes deliberately manipulated or co-opted by warring parties for political or military purposes. It may involve the diversion of humanitarian resources to support armed actors or other aims, or there may be impositions of conditions on aid delivery. Addressing this shrinking humanitarian space in today's armed conflicts requires efforts by states, non-state armed groups, humanitarian organizations, and other stakeholders to uphold humanitarian principles and strengthen respect for IHL. This includes advocating for improved access, protection and support for humanitarian actors, and engaging with local communities to build trust and acceptance of humanitarian assistance. The Geneva Conventions and IHL more broadly mandate a license to carry out impartial humanitarian action. This puts the onus squarely on the parties to a conflict to provide rapid and unimpeded access to people in need. Humanitarian space is created and upheld by respecting the law. These are laws which states have already agreed by consensus. So addressing these challenges requires efforts from the international community. But despite its failures and challenges and its limits, IHL, I believe, is the best framework we have available to provide a sliver of humanity to millions of people who are caught in the crossfire of conflict, reminding them that even in times of war, there are laws that protect their rights and dignity. And I look forward to hearing from the other panelists today. Thank you.
Super, thank you. Against that backdrop, the introduction, knowledge of international humanitarian law, I would turn to Professor Dr. Derejko. Recent conflicts have revealed this increasing maybe disregard for international humanitarian law, and question, what do you think some of the greatest challenges might be?
Thank you for the wonderful presentation, Karyn. I've jotted down 6 things that I think are key challenges with international humanitarian law today, and I'll try and just run through them really quickly. but I'm not going to contextualize them into specific contexts or conflicts, but if you want to ask questions based on those to the context after in the question and answer period, that would be great. So the first one I'll go through really quickly is there's a general lack of understanding of what IHL is and is not. And so just to clarify two things, that IHL must be distinguished from the jus ad bellum. That's the law that regulates when states can go to war, right? And so IHL is not concerned with that at all. Whether the war is a war of aggression or an illegal war, an unjust war, has no bearing on the application of international humanitarian law. International humanitarian law binds all parties to the armed conflict equally, even if one party is a state or a rebel group or a terrorist organization or a drug cartel, has no bearing on the application of the law whatsoever. Okay? International humanitarian law is not concerned with who started the war, who's going to end the war, when will the war end. It's indifferent to all of those things. As Karyn highlighted, all it does is regulate the conduct and consequences of hostilities in a very neutral fashion. When we see over the last 24 months, IHL has been thrust to the forefront of international concern and debate, primarily with regard to two conflicts, Ukraine and Gaza. And I think that right now, I've been studying and working in IHL and human rights law for 20 some years, and I've never seen, one, IHL at the forefront of such discussion all over the world, but two, such a use and abuse of IHL in the media, by states, by parties to the armed conflicts, by humanitarian actors, by political MPs in parliaments in Canada. Because there's such a profound lack of understanding of IHL, you can almost say anything. Oh, but the law requires A, B, and C. And because nobody knows what the law actually says, we just move on like that. You can publish something on Twitter or on Facebook, and even though it's untrue, nobody really hears about revoking it. Oh, that wasn't untrue, I misinterpreted the law. And if we look across Canada, we're all to blame in this sense of how many law schools in Canada are teaching international humanitarian law in law schools, how many programs are there? Of course, the Canadian Red Cross has a mandate to disseminate international humanitarian law, and it's been doing this for decades in the ICRC, but there's lots of work to be done. So what international humanitarian law is and is not is the first challenge. The second challenge is we've seen this shift from, there's two types of armed conflict in international humanitarian law. International armed conflict, which is a war between two or more states, and non-international armed conflict, which is a war between a state and a non-state actor. So it's basically the legal term for civil war, okay? Now, previously, international armed conflicts was the predominant form. But post-1977, now the predominant form of armed conflict is non-international armed conflict. And this raises a number of challenges. First, the number of treaty provisions or rules that apply to international and non-international differ greatly in terms of there's hundreds of rules that apply to international armed conflict, and only dozens of rules that apply to non-international armed conflict, treaty-wise. Of course, customary international law has kind of harmonized the applicable legal framework, but the second challenge is, in international armed conflict, everything is predicated on legal status. Soldiers of the state have a legal right to participate in hostilities, they have prisoner of war status, they can't be charged for killing other soldiers or blowing up other military objectives. In non-international armed conflict, none of this exists. So we don't know precisely when a non-international armed conflict begins, when it ends, its geographical scope. The law of non-international armed conflict doesn't define who's a civilian and who is a combatant and how to make that distinction. It doesn't require combatants or members of armed forces to wear uniforms to distinguish themselves from the civilian population. There's no prisoner of war status. It's unclear when you can detain someone in non-international armed conflict and how long you can detain them for, when they need to be released. So we have all of these profound challenges in non-international armed conflict that don't exist in international armed conflict. And what this means for the application of international humanitarian law is it provides states with a massive amount of discretion in how to interpret and apply the law during non-international armed conflict. And we see this come to the fore in the so-called global war on terror, post-2009-11, where all of a sudden states realize that classifying a situation of armed violence or a military operation against a terrorist organization, it's better to classify it as an armed conflict, because then we can use international humanitarian law, which kind of modifies the default legal regime, which is international human rights law. Okay, and there's a complex relationship between international humanitarian law and international human rights law during armed conflict. Third, there's a profound disagreement on the technical application of international humanitarian law, and I'll highlight two things. One is the concept of military objective. We know that a military objective is not defined in the abstract. It's any object defined by its nature, use, location, or purpose can transform an object into a military objective, which means it can be targeted. But the question we're seeing now is that, so if something becomes a military objective, can the entire thing be destroyed? We see this obviously in Gaza right now. So let's say a civilian building is being used by members of the armed forces to launch attacks. That would make that building become a legitimate military objective under international humanitarian law. It would still be, whether it could be attacked would be subject to the proportionality equation. But the question is the whole building a military objective, or is it just the parts of the building that's being used? And this relates to the question of can a party destroy the entire apartment complex, or they have to just take out with smaller munitions 2 floors of the conflict, or just of the apartment building, or just take the roof off of it, right? And the examples you can use is that make it clear is like, if rebels are hiding in a forest during a non-international armed conflict, it doesn't mean that the party can burn down the entire forest, right? Just because they're hiding behind 5 trees or they have a little base in there, you can destroy that part of the forest, but you can't destroy that whole thing. Now, international humanitarian law makes clear that if there's a bunch of buildings in a neighborhood, some of them are being used as rebel bases, but others are not, but they're all commingled. You can't treat that entire area as a single military objective. You have to disaggregate it, even if it, poses challenges in the application of the law. The second problem, so we need to define more clearly what the external parameters of a military objective are. And we can start applying this to underground tunnels, to apartment buildings, to forests, to the natural environment. The second one that's intimately related to this is the question of proportionality. Now, a proportionality in attack during an armed conflict, it's basically the rule that says that if an attack is expected to cause an excessive amount of civilian deaths or civilian harm, you can't launch the attack no matter what. Okay? The word is excessive, not lots or many or a shocking amount. It's an excessive amount. So what is an excessive amount of civilian harm or civilian damage, and who decides that? And here, I've been at trainings at International Humanitarian Law Institute with military commanders. I do training on the application of human rights law to armed conflict situations. And when we do scenarios, the striking thing is that military lawyers from different governments will have different perceptions on what is proportionate. So I give this idea of, a rebel base under the cafe's full, 25 people, can you take out the rebel base? Take out the cafe to get to the rebel base. Well, one government will say, well, my government would allow 10 civilian casualties to that. Another government will say, well, my government would allow 20 civilian casualties to take out that main headquarters. And another government will say, well, my government would allow 30 civilian casualties. And right now, we don't know what is the true answer. Like, what is a disproportionate amount of harm to civilians to pursue it? What we do know is that you can't link that to the overall objectives of the armed conflict, because that's linking the jus ad bellum, the reasons for going to war, and the jus in bello. Those always have to remain separate. Okay, so that's technical application. There's a whole bunch of other challenges that emerge with the technical application of the law to specific contexts. And we're seeing in recent conflicts, there's new scenarios emerging on the technical application of the law is never done before, and so a number of questions arise. This fourth one is enforcement of international humanitarian law. So there's a number of things that need to be said on enforcement. One, international law doesn't enforce itself, whether it's human rights law, public international law, all of these things, international criminal law, it's dependent on the political will of states to enforce. International law is always bound by consent. States sign up, and they agree to be bound by it, and they agree to implement their obligations. If they don't, international humanitarian law can't be implemented effectively. And so we see Article 1 of the 4 Geneva Conventions imposes this obligation on states to not only respect IHL, but to ensure respect for IHL. And this is a negative positive obligation thing. For any of my human rights law students in here will be very familiar with the differences in scope. So the question becomes, how far do states have to go to ensure that other states respect IHL even though they're not a party to the said armed conflict? The case in point is obviously, what are Canada's legal obligations to ensure Israel respects international humanitarian law? We'll see, call for a ceasefire, impose an arms, a two-way arms embargo on it, all of these different things, whether it's Sudan, Israel, Russia, all of these different things. So the question of Canada's legal obligations towards current armed conflicts comes from that Article 1. Enforcement, IHL lacks its own internal mechanism of enforcement. It was one of the big shortcomings that we all saw following 1949. We don't have any enforcement mechanism. All of this, all the rules are based on the touchstone of a reasonable commander is responsible for implementing all of these rules and ensuring everyone under their subordination in the chain of command follow those rules, and they can be held criminally responsible. The primary way that international humanitarian is enforced is by international criminal law. And we could talk hours on the advantages and limitations of international criminal law, but I think that it has a number of limitations. One, it's very selective, right? We can see that in the track record of the International Criminal Court. Victor's Justice, there's entire books, sections in libraries devoted to this entire topic. But I think from my perspective, there's two things. One, it's always retrospective, right? And this is the problem, that it's always looking back, saying that if we punish these individuals for breaking these rules, it'll be a deterrent for the future. Now, whether the history of international criminal law supports this is very much debatable. Two, and my big problem with it, is that it's always individualized, right? So the state gets off scotch-free. It's like, yeah, punish the commander, the military commander. And often, if we look at the record of the International Criminal Court or the criminal tribunals, we're talking low-level commanders, if not foot soldiers, taking the blame for huge state apparatus, right? So it doesn't put any pressure on the state to change. We could revert it back to public international law, but the mechanisms there are even weaker in state responsibility because we have this predominance to go towards international criminal law and mass atrocities and all of these things. And I think that's very problematic. I think that's the only ones that I included. So yeah, I think we can leave it at that, and then I'm happy to answer questions at a later time. Thank you.
Great. Well, thank you, Nathan, for expanding upon and offering those points. That's excellent. Now we turn to Dr. Anderson to maybe address some of these issues, or certainly raise the questions about human rights or notions of responsibility post-conflict and during conflict. So
thank you, and thank you to my fellow panelists as well. So I'm an international criminal law person primarily, so that's also how I'll approach things today, and that's sort of that's also the lens through which I look at IHL to some extent, and so that's my starting point, I would say. I would defer to my colleagues in terms of expertise on specific IHL questions as well, I'll say. But starting, I would like to pick up on a couple of the points of my co-panelists in terms of, I guess, some of the challenges that we see in IHL. I think I definitely share, what Dr. Derejko was saying in terms of the inability to distinguish between jus ad bellum and jus in bello, there are very good reasons why these bodies of law or these legal principles are considered to be separate. And as he was saying, essentially, not to put words in his mouth, but essentially no matter the justness of your cause, whether it's, there are a lot of causes we can think of, whether it's self-defense or self-determination or whatever the cause may be, you are still bound by the laws of armed conflict. You're still bound by international humanitarian law. And that restricts the way that you actually conduct an armed conflict. So in popular discourse, there is a ton of blurriness, I think, in terms of this distinction between jus in bello and jus ad bellum. And a lot of arguments I see kind of in the public realm are basically saying because this thing is just, we can do whatever we want. And that's hugely problematic from a human rights perspective, from an IHL perspective. I also think, as Dr. Derejko said, this kind of tension between military necessity and proportionality, which is, of course, baked into IHL. It's a really fundamental aspect of IHL. Again, when I look at the way people talk about IHL kind of in the popular realm and governments as well, it's kind of all military necessity, no proportionality, which is obviously hugely problematic because, again, it kind of plays into the argument that essentially if there's any military objective present, as Dr. Derejko was saying, to take it in extremis, if there's one soldier present, then you could just sort of carpet bomb the whole area. And that, of course, is not accurate. That's ignoring the proportionality side of things, which is crucial to the way IHL actually functions. On kind of pivoting to the broader perspective in terms of bodies of law that apply, I think I think there's always an issue in law of timeliness. So I think the law is essentially always behind. You know, if we look at the way that armed conflicts are actually conducted, and if we look at, as I think Dr. Derejko was saying, and you were saying as well, Karyn, but the kind of emergence of new technologies and the challenges that poses for IHL. I mean, there are certain, in international criminal law, there are certain weapons that are, and in IHL, there are certain weapons that are explicitly prohibited, but then there are a lot of other weapons that are probably prohibited because they cause unnecessary suffering, but we don't know exactly. There might not be a convention prohibiting them. So in a sense, the law is always behind. The law is always, or mostly maybe I would say post facto as well. We're dealing with things after they occur. I mean, when I look at international criminal law, the kind of part of it that maybe isn't post facto is what's sometimes called preventive statements by the prosecutor. We can definitely question how effective these kinds of statements are, but the prosecutor, actually the former prosecutor more so, Fatou Bensouda, made these kind of statements very often, where basically they look at a particular situation and they remind the parties that they need to abide by international humanitarian law and international criminal law. So that's actually an attempt to kind of have a deterrent effect. Of course, deterrence, whether we look at international criminal law or domestic law, is a very, very contested concept. I'm pretty skeptical of deterrence as having any kind of effectiveness, you know, and when in my own work, I've spoken to a lot of perpetrators of atrocities, and that was actually one of the things that I would ask them in a more roundabout way, but were you thinking about the law when you did these things? And the answer is inevitably no. And if I follow up and say, well, why weren't you thinking about the law? The answer is because we thought we would win. You know, so that's basically, and often they do win. You know, so often perpetrators are not held to account, which is also, you know, coming to what Dr. Derejko was saying about the selectivity of international criminal law, which of course is dealing with individual criminal responsibility. So it's a common point of confusion. It's not dealing with the responsibility of states, unlike the ICJ, the International Court of Justice, of course, is focused on state responsibility. So it's only dealing with individuals, and because of this, usually you're dealing with a very small number of people, at least at the international level. The principle here is that people will be primarily prosecuted at the domestic level. Sometimes that takes place. Often it doesn't take place. If the side that is committing the atrocities stays in government, it does not take place. Even when we talk about the international criminal level, of course, people can certainly be charged with international crimes. Heads of state have been charged. In some cases, former heads of state, I should say, have been convicted of international crimes. So there is sometimes accountability for leaders, but this usually takes place many years after the fact, and usually effectively once people are out of power. Well, you're the president of a country. I mean, just imagine if you're the president of, I don't know, we'll say pick a practical example. You're the president of Kenya and you're charged with international crimes. Is Kenya then going to cooperate with the International Criminal Court or with universal jurisdiction proceedings or any of these things? No, they're not. That's a very easy answer. They're not, because of course they're self-interested. So that is, I think, a challenge that underlies international criminal law, which from a certain perspective is kind of about the enforcement of IHL. That's probably not an exact translation, because it's about a lot more, I would say, than the enforcement of IHL. But if we look at war crimes, of course, war crimes are essentially the enforcement of IHL. So the Rome Statute, of course, makes the war crimes provisions are structured around the Geneva Conventions. So some provisions, well, I'm probably going too deep here, but some provisions are, you know, related specifically to Common Article 3. They might not mention Common Article 3, but that's what they're about. And of course, the provisions on international armed conflict are separated in the Rome Statute from the provisions of non-international armed conflict. So in a sense, it is the operationalization of IHL. But international criminal law also deals with other things, of course. It deals, when I look at the Rome Statute, when I look at the International Criminal Court, it deals with the crime of aggression, which is, in some senses, the newest international crime, in other senses, not the newest international crime. Of course, it deals with genocide, it deals with crimes against humanity. Again, there are a lot of misconceptions about what these terms actually mean, which are I mean, one of the challenging things I think about all this is that these are, of course, legal terms of art, but they also have kind of a life in popular parlance. In a way, I think that's obviously a good thing. I think it's a good thing that people are talking about human rights, that people talk about the law of armed conflict, that people talk about things like genocide, but often they're not correct in their interpretation of the law because they're not, they're just not well versed in what the law means and what the law doesn't mean. So I mean, when I look at genocide, which is even more so my area of focus, I think the common conception is very much shaped by the Holocaust, which is, I think you could say, is really the paradigmatic case of genocide. It's certainly not the only case of genocide. I mean, well, it depends how you want to count it, but I would say that there are hundreds or thousands of cases of genocide throughout history, in fact. So that conception is very focused on mass killing, which is also not even an accurate depiction of the Holocaust, in the sense that, of course, the Holocaust, the mass killing aspect of the Holocaust was crucially important, but there were many other aspects that accompanied mass killing, like cultural genocide, for example, like the destruction of Jewish people as a culture, the attempt to destroy Jewish people also as a culture. But when we look at the Genocide Convention, of course, the Genocide Convention includes kind of 5 criminal acts, and killing is only one of those 5 acts. So also when I see kind of pushback against the application of the Genocide Convention, and the Genocide Convention has this kind of, in international law, it's almost considered the holy of holies, and there are also some problems with that kind of perception, in the sense that it's kind of got this normative weight that makes it seem to be the most important international crime, and maybe there are some arguments that it is the most important international crime, but that kind of sacralization, I think, can be damaging in terms of applying the convention. But when I look at the ways people apply the convention, it's very, very much focused on mass killing. And I often see that argument, well, even in terms of the residential school debate in Canada as well, I see the argument from many politicians, from commentators, people who've never bothered to read the Genocide Convention. They say, well, this isn't mass killing, so therefore it cannot be genocide. Of course, genocide includes these other acts, which I probably don't have time to enumerate right now, but things like the forcible transfer of children from one group to another group, things like deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part. So there what we're really looking at is things like famine. The intentional infliction of famine would be a classic example of that. Putting people in concentration camps, working them to death, starving them to death, all that might fall under deliberately inflicting conditions of life. So the Genocide Convention and the concept of genocide as a legal concept is broader than most people think. But of course, it's also very much tied to the intent requirement, which is that it has to be to destroy the group in whole or in part. So there is, I mean, when I look at the application of international law in general, yeah, there are a lot of misconceptions, I think, about the way the law applies. There's a lot of confusion about differences between individual criminal responsibility, state responsibility, IHL, or international humanitarian law, international criminal law, human rights law, which I know Dr. Derejko is also an expert on this question, but human rights law also applies during armed conflicts. So I think, yeah, in a way that normative confusion as well can also, to some extent, I think, can undermine international law, including the application of IHL as well, because there's a lot of confusion about which laws apply, where there's less confusion, of course, among experts, but I'm talking about politicians, on the kind of use and misuse of international law. Do I want to say anything more now? Maybe not, actually. Yeah, I think that's good enough for now, but I'm sure a lot of other things will come up in discussion and in questions. Thank you.
Excellent. Well, thank you. Thank you, Dr. Anderson, for that introduction. And so you can see from all of these panels that the full extent that we're talking about in terms of the international humanitarian, trying to focus on that, but in all its discrete aspects, some of which were covered here, but there's tons of them. So you can see the fulcrum of the discussion we're trying to have. So maybe sort of flowing from what's been introduced, I have a couple of questions here. Maybe the first one would be to Karyn Stone would be, when you talk about the entity in which you're involved, the international, the Red Cross, maybe lost bias towards neutrality, but certainly when we talk about the Red Cross, one of the pieces of its identity is the importance of neutrality in all of these situations. And I wondered if you could speak a little bit about the importance, the centrality of the notion of neutrality, particularly for that institution. So I'll just leave you with that one first, if that's all right.
Yeah, sure. Yeah, as you mentioned, the notion of neutrality is really central to the work of the Red Cross, but other humanitarian organizations as well. It's one of the main or fundamental humanitarian principles. For the Red Cross, Red Crescent movement, we have 7 fundamental principles. Humanity, neutrality, impartiality, and independence are probably the most important for this discussion. And I think neutrality is often the principle that's the most misunderstood and probably the most contentious. And I can certainly understand why it's questioned. But neutrality doesn't mean that the Red Cross is complacent, and it doesn't mean that the Red Cross is silent. But it's important to ensure that when there's an armed conflict, when there's a situation of violence, we don't take sides. So we don't come out with public statements against one side or the other side. Our main focus is to provide life-saving aid. And so not only can we not take sides, we can't appear to take sides as well in our speech or in our actions at any time or any place. But we're not neutral to suffering, and we're not silent. We maintain confidential dialogue with parties to conflict, whether it's states or non-state actors, and we raise concerns about things we're hearing, allegations of IHL and other things. But we're not a organization that will make public statements, and we do this to reach people in need. Without this fundamental principle of neutrality, we would not be able to operate in the ways in which we operate. We wouldn't, our staff and volunteers in conflict zones wouldn't necessarily be safe, nor would they be granted access to areas under control of armed groups or armed actors. And our ability to provide safe, life-saving aid would be restricted. Now, this notion of neutrality also applies in times of peace. So even when there's not an armed conflict going on, for example, in Canada, we're in a time of peace right now, we still need to have this central principle of neutrality in our work. Because when conflict, when violence, when political disagreements break out, we need to be able to do our job well. So yeah, and I think neutrality means different things to different organizations. I think the Red Cross, Red Crescent movement has quite a strong formulation of this concept, but you may find other humanitarian organizations where they may be more vocal. Médecins Sans Frontières, which I've worked for in the past, is one of these organizations that does sometimes make public statements. And again, it depends on the organization, but it's absolutely essential for the work that we do. We have many colleagues around the world who are working right now in situations of conflict, and if they were perceived to be against armed actors in any way, this could really put their lives, their safety at risk, and limit their ability to support people that need this life-saving aid.
Thank you. Rising from a point that was made earlier about the autonomous weapons, one question I would sort of direct would be, we've sort of seen recently sort of changing technology and maybe the challenge of modernity. We've seen new battlefield technologies emerge, autonomous weapon systems and things like robots that can kill. We've also seen nuclear weaponry, weapons of mass destruction. So I wondered, one question I would have for you, Nathan, would be also along with that, we've seen new spaces for attacks, so both the cyber spaces and outer space. And one question would be, so thinking about all of these, I think you kind of alluded to some of whether international humanitarian law is fit for purpose, but I wondered if you could sort of comment on these a little more fully on these modern challenges.
Yeah, sure. Those are three big modern challenges. So maybe I'll highlight what I think in each of those aspects is one of the predominant challenges. I think first, technology in war has a very, very interesting history. And if we look at a subset within international humanitarian law is the law of weaponry. So we can have different specializations in the law of war. You could be like a civilian protection person, a weapons specialist who can identify weapons. So in the law of weaponry, if we look back, let's go back 5, 6, 7, 800 years. If we look back, with every advance in the law of weaponry, we see an outrage and we see a panic on the need to develop new laws or new rules, or should this be allowed? And probably one of the most famous examples is the Vatican's objection to the crossbow. That was the first kind of weapon that could shoot and project force at a greater distance. And the Vatican said that this was so unjust and so inhumane that it must be categorically prohibited. And then, let's fast forward a few hundred years, and we had the advent of drones into the arsenal of armed conflict, where we have an individual sitting in a small little cabin in Nevada desert, but, operating a drone over the desert in Yemen and targeting individuals participating. And the question was this massive disjunction between participating in the hostilities and where the hostilities are, is this lawful? Should we prohibit it? And we saw at the beginning of this debate, we're like, we must prohibit drones. It's going to, destroy our humanity and will be incompatible with international humanitarian law. But, 20 years after the advent of drones, we see that they are regulated. There's quite a number of regulations and they're not incompatible. The most recent manifestation of this now is what? Autonomous weapon systems. And we have two camps, like ban autonomous weapon systems because we're going to, it's going to result in like Terminators that are going to come over, and Skynet will take over and we'll be fighting the robots and not each other. And there's the other camp that says, no, let's regulate it. We're not going to prohibit it. And if we look at the history of banning nuclear weapons, landmines, all of these things, it's unclear whether states will accept a categorical prohibition on autonomous weapon systems. And if not, like, I would love to prohibit all the weapon systems. We don't want to develop more weapon systems. I think this is a bad thing for humanity, and it costs us too much money. Let's develop medicines for, diseases and all of these things, and affordable housing for people in Winnipeg rather than new weapon systems. But that's not the world that we live in, unfortunately. So I guess one could say, should we ban it or regulate it? And I think with autonomous weapon systems, one of the main problems is who's going to be held accountable when we take humans out of the loop of targeting decisions. So when the robot goes rogue and starts killing children and civilians, the government will just, who's responsible? Is it the commander that deployed the robots on the field? Do we take apart the robot and say, bad robot, you go to the International Criminal Court? We have this deterrence for the other robots. Do we, is the criminal liability going to be the programmer who's operating the robot? What about the company that made the microchips for the robot? And I think all of these questions put on who is responsible, but I think there's a really big catch for it, is that if a state deploys a robot onto the battlefield that's an autonomous weapon system that's going to make its own decision, the state is responsible for that robot. It's a party to the conflict. It will be responsible if that robot was a human or not, even if the state says, well, the algorithm wasn't supposed to do that. The developer sitting in, the Silicon Valley in California told me the algorithm was only going to do A and B, but it went off and did these other 26 things, so I'm not responsible. We can't have that kind of like liability just erased. So I don't think there's a huge number of problems with algorithms making targeting decisions and taking humans out of that loop, but what is going on right now is that it's not completely out of the loop in all cases. There's a human at the end of the loop that just reviews. The problem that we're seeing in armed conflicts today is that algorithms are choosing massive targets. So where a human picks 15, 20 targets a day, an algorithm picks 300 targets a day. And so you have one human just saying yes, no, yes, 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 yes. And there's not that oversight or accountability or the precautions necessitated by international humanitarian law to verify. International humanitarian law has these strict requirements of precautions precautions during, and precautions following attacks. And all of those aren't taken into account when autonomous systems are either identifying targets or selecting targets on their own. Cyberspace, there was this question on, do we need a new treaty now for cyberspace? We have to, does international humanitarian law, which was developed to regulate individuals on the battlefields and all of these different things, do we need a new treaty for cyberspace? Well, if you look at the history of international humanitarian law, like let's go back to the Liber Code of 1864, one of the first ever pieces of international humanitarian law that regulated the Civil War in the United States. Well, this one was designed to regulate the armies in the field. Now, if we go to 1977, one of the most recent IHL codifications, it regulates attacks in cities and towns and villages. So the whole codification of the history of IHL shows that once wars were fought in fields where armies literally lined up, opposed each other, and walked towards each other shooting, and whoever had the most soldiers would win the war. But now, as Karyn's mentioned, it's all urban warfare. It's increasingly in urban centers with a mingling of military objectives, civilians, combatants, rebels, fighters, cartels, all of these different things. But the question remains is, we always see these new calls. We saw this following the so-called global war on terror, where the United States government tried to say, well, none of these laws apply, and so there's no international law that regulates, the global war on terror. Obviously, 24 years later, now we realize that that's categorically not true, and that these laws are quite effective in regulating all this. So with cyber, the question is, much of the use ad bellum and use in bello can be applied in the cybersphere. And I think one of the main questions, if anyone's really interested, is how do we classify data in a cyber conflict? Like, if data can ever become a military objective and you can just target data, which holds reverberating implications. Basically, governments and think tanks and IHL experts are all divided on whether data should be a military object or a civilian object, and if it's used for military purposes, when can it be attacked? We see the external manifestation of this in contemporary conflicts. If we look at the Starlink, Elon Musk's Starlink system over Ukraine, right? Russia knocks out Ukraine's satellite systems. Ukraine asks Elon to give them Starlink systems so they could have internet access to coordinated attacks. Elon Musk says yes, so Starlink goes over Ukraine. Ukraine can coordinate military operations. Russia comes back, tells Elon Musk, if you don't stop doing that, I'm going to start targeting the satellites in outer space and I'll destroy them all. Elon Musk is like, they're not even finished being built. Pulls back, says, sorry, Ukraine, you can't have the Starlink system anymore. But this just shows how going from cyberspace now to outer space. And so one of the new frontiers in international humanitarian laws, how does all of this law originally designed to apply in this field with battles apply in outer space? And we see that armed conflict has already moved to outer space in the sense that most of our intelligence and coordination efforts in contemporary armed conflicts are done by satellites now. And what that means is that all of those satellites are military objectives. So the question becomes, if they are military objectives, can they be attacked? And if so, when and under what conditions? And what does a disproportionate attack look like in outer space, right? And so we have questions of like debris falling onto Earth from outer space. We have the reverberating implications of knocking out satellite systems, which knocks out banking and hospitals and trains and transportation coordination and all these different things. But it looks like now this new frontier of outer space and the laws of war will become of increasing significance as states put more military infrastructure in outer space. Except for the moon, there's a treaty, the Moon Treaty, the Outer Space Moon Treaty. We're not allowed, 1950s or 60s, that the world adopted the treaty that regulates the moon, and we're only allowed to use it for peaceful purposes. So you're not allowed to put military installations on the moon. It would have been really good if way back then they would have said, let's make outer space neutral territory and not put any militarized aspects in outer space. But they didn't. They only did it for the moon. So now we have military objectives floating all over and huge technical discussions on how we're going to regulate armed conflicts in outer space. I don't know if that answers the question.
No, thank you. That's great. Thank you. Maybe just ask, I'm not sure if there are any questions emerging online or in the room, but
maybe you can see one more question to the panel, and then we'll start just taking questions from in the room and online. We're starting to get questions online as well.
Okay, perfect. Maybe just one for Dr. Anderson, which would be sort of, you've mentioned this distinction between individual accountability for criminal activity and holding states to account. And I guess I was wondering in that context if you might be able to speak a little bit about things like immunity and whether, I know there's sort of a recent shift. Somebody was sort of talking about this idea that individuals who are actual soldiers who are involved in war could be held to account under international criminal law for sort of being part of an aggressive act, the crime of aggression. So I'm just wondering, there seem to be new pieces, or certainly, and I wonder if you could speak a little bit more about, particularly about that distinction between state responsibility for criminal pieces and individuals, both as heads of state, but also as simply either a combatant or as a soldier.
That's a complicated question, actually, definitely. But because I think, of course, there's the concept of head of state immunity, which is pretty well embedded in international law, and there are different versions of head of state immunity. Without going into all the nitty-gritty details there, there's no immunity. Yeah, well, I could say the International Criminal Court doesn't recognize head of state immunity. There are more complex questions in terms of countries which are not a party to the Rome Statute, because kind of a general principle of international law, there are many exceptions, but kind of a general principle is that in order for the law to bind you, you have to actually agree to it. That you have to. Normally, this occurs, of course, through ratifying a treaty. There are exceptions there, as I said, like customary international law. But in terms of individual foot soldiers, well, under the Rome Statute, you certainly couldn't hold like a low-level soldier responsible for the crime of aggression, because it's, I don't remember the exact language, but it is embedded in the definition of aggression in the Rome Statute that basically you're only dealing with people who have planned and devised the war rather than, a soldier who's carrying it out. Of course, under IHL as well, you are, well, especially in international armed conflicts, or only in international armed conflicts, you can't be prosecuted for mere participation in an armed conflict. Because if you're considered to be a combatant, essentially, you can't be prosecuted for things like treason, for example, because of course it's one state fighting another state. When you get to the domestic level or a non-international armed conflict, that changes, and that's a whole complex morass there. But at the domestic level, you can be prosecuted for participating as a rebelling against the state, for example. But yeah, so I'm not sure if I've answered your question, but there are a lot of kind of overlapping legal issues there. Maybe I'll just make one more point, actually, in terms of what it means to individualize responsibility versus having state responsibility. Because of course, when you get to the level of individual responsibility, when you get to the level of crimes, then you have to prove, as with any crime, that a criminal act has occurred. You have to prove that the person who committed the act, you have to identify that person. You have to prove, of course, that they committed the act with the requisite intent, and there's different intent for different crimes as well. So necessarily, when you get to international criminal law, again, you're focusing only on individuals that you have evidence for. So there's kind of an overlap, of course, with the state. If you're prosecuting somebody like a head of state, and obviously it's usually occurring or always occurring within a context of state violence. But at the same time, you're focused on evidence you have against specific individuals. So that means that there could be many individuals who could be responsible or who could have committed crimes that you just don't have evidence for, or that you choose not to prosecute for other reasons. So it is inherently quite selective, and you sometimes try to get at the more systematic aspect by different modes of liability, and again, we're getting to complex stuff there, but when you look at things like joint criminal enterprise, for example, and there are a lot of different versions of joint criminal enterprise, but basically where you're participating knowingly in a criminal organization, and that criminal organization in terms of international crimes could be something like the SS, going back to the Holocaust, or it could be, an authority that's running a concentration camp, for example. And again, there are different versions of how far that kind of responsibility can extend. In the case of prosecution of former Nazis in Germany today, and it was very different in prosecutions in the 1960s, then people are being prosecuted who were accountants, who were literally, the so-called bookkeeper of Auschwitz, because that was contributing to this overall enterprise of running Auschwitz, which of course was engaged in genocide and engaged in mass killing. So this is somebody who would have certainly would have never killed anybody, So that's kind of the broader kind of notion of connecting people to this organizational responsibility, but there are a lot of different ways of doing that, and some parts of that are definitely contested.
you, thank you. Simply underscore that a lot of Dr. Anderson's work actually touches on, like, it's based on interviews with particular people who, participated in War of the Soldiers. So if you're looking for more understanding, that'd be a great place to look.
And
So
some leaders as well.
Oh, okay, perfect, perfect. So we would like to, we have a few minutes. If everyone's all right, we'd like to open it up because we said it was participatory. So we're wondering simply whether anyone in the room has or online has a particular question that you'd like to share or ask the panel now that we have the expertise here with us.
So I have a question online. It's pretty well written and a good place to start, I think, and then we can of course open it up in the room. So I'm just going to read the question exactly as it's written. How does the misuse of international humanitarian law by one side, an example being hiding in schools and hospitals, use ambulance to transport weapons, pretending not to be a civilian and need to lure the other side, impact or not impact the expectations on the actions of the other side?
Yeah.
Speak to that. I know you can speak to it in more detail, I'm sure both of you, but I mean, what we're sort of talking about is what's called the crime of perfidy. And the basic principle there is that, yeah, by misusing things like the emblem of the Red Cross, that you're actually, that essentially you're undermining international humanitarian law. Because if you say the Red Cross is a protected symbol and that therefore you cannot attack an ambulance or a hospital, there are other reasons you can't attack ambulance or hospitals, then if people are misusing those kinds of things, then of course it also would potentially undermine adherence to international humanitarian law. So there is sort of a, I guess there's the use of tactics like that, and there, of course, that doesn't mean that it's unlawful necessarily to trick the enemy, but it's really about misusing humanitarian law and using humanitarian law essentially to shield yourself, which is itself in that sense.
Anyone else like to?
You want to go? So absolutely nothing. It doesn't relieve the attacking party's obligation or modify them in absolutely any way. Using the Red Cross symbol is a war crime. Human shielding can be a war crime. We can have technical details on perfidy or what shielding is or human shielding, but it in no way alters the corresponding obligations of attacking forces no matter what. If they're civilians, they're taken into the proportionality equation no matter what. If they're directly participating in hostilities, those civilians are not taken into the proportionality equation. But other than that, it doesn't alter. If one side violates the law of war, the other sides can't be like, oh, we're not going to, abide by the laws of war because they're not abiding by the laws of war. Within hours of the war starting, that means there's no one abided by any laws of war, and it doesn't work that way. Everyone's bound by the rules, no matter what the other side is doing. You can't say, well, they're not fighting by the rules, so I'm not fighting by the rules. It has no bearing on the application of international humanitarian law.
You said it.
Okay, perfect.
In the room.
Okay, anyone in the room have any, please, and then behind you, sorry.
And nice and loud so that everyone online can hear you, please.
Hi, my name's Paula. I'm first year PhD Peace and Conflict Studies. Just to follow on what you were talking about, war crimes, I'm wondering if the panel could speak to the difference between IHL, war crimes, and crimes against humanity.
Sure. I can start and then maybe you want to flesh it out, or? So war crimes, basically in international law, we have primary and secondary rules of international law. And war crimes are the secondary rules of international law that criminalize the primary rules of international humanitarian law. So the first requisite for a war crime to be is the existence of an armed conflict. And this is what I mentioned, that right now we don't know when an armed conflict begins, which has this jurisdictional scope for International Criminal Court. So the first thing, all the defenses of all the criminal tribunals to date, the automatic defense, the initial defense of all the defense was that at the time and place where the alleged offense committed, there was no armed conflict, and therefore there can't be a war crime. The absence of an armed conflict negates the possibility of a war crime. So you need an armed conflict, and there needs to be a nexus between the act and the armed conflict for it to constitute a war crime. Crime against humanity has now been divorced from the existence of a war crime. A crime against humanity is basically a widespread and systematic attack, is the language, against the civilian population, right? And so it can occur in peacetime or it can occur during wartime. So it's not predicated on the existence of an armed conflict. And then there's specific acts that would constitute a crime against humanity. I think that international criminal law has this really annoying habit of trying to create a hierarchy of crimes. That genocide's at the top, and then we go to war crimes and crimes against humanity. It's only international criminal law that really does this, and I think that it can be completely disregarded. I think that there's specific requirements. Genocide has a special double intent that needs to be approved. War crimes are predicated on the existence of an armed conflict. Crimes against humanity need to be widespread and systematic and involve an attack. So they all have different nuances and elements, but I would very much discourage against creating a hierarchy of crimes, because war crimes can be just as severe as crimes against humanity and vice versa.
Yeah, maybe I'll just add, I mean, just on a very basic level, and Professor Derejko definitely spoke to this as well, but the main distinctions are essentially the context. I mean, the act is also a little bit different in these cases, but you can have the same act, you could have something like torture become a different crime depending on the context in which it occurs. So as Dr. Derejko is saying, crimes against humanity have to be widespread or systematic. They have to be part of an attack on a civilian population. There's some debate about whether crimes against humanity can also occur against combatants, but the kind of basic version is it's against a civilian population. They can occur in war or in peacetime. So if we looked at Nuremberg, the Nuremberg tribunals, at that time there was what was called a nexus, which meant that crimes against humanity had to be connected to the waging of aggressive war. That nexus is long, long gone, so you can definitely have crimes against humanity absent a war. As Dr. Derejko said, of course, war crimes have to occur in the context of a war, and you would determine whether it's an international or non-international armed conflict because different rules apply, and that would happen in the first case at really any tribunal, any new tribunal or any new situation at the International Criminal Court. That would be one of the first questions that really needs to be settled. Is this happening in the context of an armed conflict? What is the extent of the armed conflict? What is the nature of the armed conflict? And of course, genocide is basically an intent to destroy an ethnic, racial, national, or religious group. So only those four groups, which again is kind of a common misconception against genocide. So yeah, the short version, you can't commit genocide against gender, you can't commit genocide against disabled people. There are obviously problems with this nature of the protected groups, but that is kind of the classic version of protected groups. Under the convention, in national law, you might find different groups protected, like in Argentina, you'll see political groups are protected under the Genocide Convention, for example. So genocide is really about destroying the group, and that can occur in wartime, it can occur in peacetime. Actually, one of the things I've seen online a lot, again, talking about misconceptions, is that if something is a war, therefore it cannot be genocide, which is kind of ludicrous if you've ever studied genocide, because genocide usually happens in the context of a war. It doesn't mean that it has to be connected to that war in any kind of formal legal sense, but more often than not, genocide happens along a war. Actually, more often than not, these crimes all occur at the same time, or some of these crimes occur at the same time. So it's very common that you would have a situation which might include genocide and crimes against humanity and war crimes and probably other ordinary domestic crimes as well, all occurring at the same time. So obviously every situation is different, but that complexity is pretty normal and pretty standard, and it's definitely not mutually exclusive that you have a war occurring at the same time as genocide.
Thank you.
Yeah, I think my colleagues have answered very well, but I just want to first thank you for your question, because I think it's really important, and I think it's a really good question, and it speaks to this, I think this confusion in the public about what IHL is and when it's applied and when it's applicable. And as my fellow panelists were saying, there is this sort of push, I think, in the public sphere to, when something horrible is happening, there's this push to give it the term that we believe is the worst term that you could apply. So there's this push to call things genocide when maybe they don't fit the legal definition. And I think these are really important conversations to have, and to really nail down the legal frameworks and what these definitions mean, because it doesn't mean that if a situation doesn't qualify as a genocide or a situation doesn't qualify as a war crime because there's not technically an armed conflict happening, doesn't mean these aren't horrific things that need to be addressed through other legal frameworks. So I really do appreciate that question. Thank you.
Thank you.
Thank you. And I think there was, maybe we have time for one more, please.
Hi, my name is Maria Shemchishin and I'm a visiting scholar from Ukraine here at the University of Manitoba, and thank you for this very interesting panel and discussion. And as far as I'm from Ukraine, so my question is about Ukraine and the situation in Ukraine. So we all know that since the beginning of the war, Russia has been destroying our infrastructure, civilian buildings, and civilians in great masses and great numbers. And different international organizations, they have been fixing these crimes, yes, against humanity and war crimes. And we believe that this is the real genocide of Ukrainians. And in your presentation, you use this rhetoric of retrospective, yes, but if being a prospective and thinking about the future, and do you see any real possibility of having an international tribunal for Russia, for commanders, for the president and for the soldiers who committed all those crimes? Thank you.
Thank you.
I mean, I don't think I'll have a very good answer for you. I think it's a tough question to predict the future. I think I believe Dr. Anderson was saying it's unlikely that post-conflict a state will extradite commanders to an international criminal tribunal, but I mean, there's always possibilities of things like extraterritorial, another country enacting extraterritorial jurisdiction over certain individuals. And I think if you look at past conflicts, we're probably the same perspective where it was believed that it was probably unlikely for certain individuals to face justice. There have been surprises. So I think there's always a possibility, but it does remain one of the big, I think, challenges of this legal system. This hope for achieving justice in an international criminal tribunal is challenging. But I think my colleagues are a little bit more versed on it than I will, so I'll pass the floor over.
Well, international criminal justice moves very slowly. That's as Karyn was saying as well. So often it's actually years after the fact that people are actually brought to justice, which is very frustrating. But I would say Putin should be careful where he takes his vacations, for the foreseeable future, as he will be. Having said that, there is also a history of people who have actually been charged with crimes, heads of state who've been charged with crimes by the International Criminal Court, traveling to state parties of the International Criminal Court, which have an obligation to arrest those people, and sometimes they are not arrested because there are some legal issues at play, but there are of course a lot of political issues at play. But if I look at Ukraine specifically, and I'm getting into complex stuff now, but the International Criminal Court does not have jurisdiction over the crime of aggression in relation to Ukraine. They have jurisdiction over the other three core crimes, being genocide, war crimes, and crimes against humanity. The reason they don't have jurisdiction over aggression is because aggression was basically added to the statute later, or I should say it was defined in the statute later, and there's a different jurisdictional regime that applies to aggression, which means that basically both the aggressor and the victim of the aggression need to be state parties in order for the court to exercise jurisdiction. Only for aggression. That's only true of aggression, not true of crimes against humanity, not true of the other crimes where you just need basic territorial jurisdiction. So the current investigation by the International Criminal Court is focused then on the three other international crimes that are included in the Rome Statute, being crimes against humanity, genocide, and war crimes. There's a big discussion, there has been really since the invasion, about then what do you do about aggression, what do you do about people who might not be prosecuted by the ICC because of this high degree of selectivity. I think the ICC maybe has charged 4 people so far. I'm slightly out of date there, but I think they just charged 2 more. So yeah, the debate there, just long story short, is whether you have a purely international tribunal, like you had for the former Yugoslavia, like you had for the Rwandan genocide, or whether you have a hybrid tribunal, which is part international, part domestic, like you had for Sierra Leone, like you had for East Timor, many other examples. And the preference of most states is to have a hybrid tribunal. And the advantage of a hybrid tribunal is seen as greater kind of benefits for the country. It's closer to basically the country in which it's operating. It might have benefits in terms of inculcating international criminal law domestically. Ukraine is opposed to that. So Ukraine favors an international criminal tribunal. And their reasons for that are basically twofold. And one of the reasons has to do with what crimes are actually currently contained in Ukrainian law. But I think the bigger reason actually has to do with what is seen as, I guess, the importance of having something that is legitimate and completely international and impartial. And in some way, I think the Ukrainian government views that as being more authoritative than something that's actually embedded also in the legal system of Ukraine. So that part is still being decided, but I think it's very likely that there will be cases eventually at the International Criminal Court. It's very likely there'll be some form of tribunal, which will probably only try aggression specifically. And it's also likely there will be some domestic prosecutions in Ukraine. Of course, again, the challenge is, as Karyn was saying, what if we're talking about crimes committed by Russia, then you have to have those people in your hands, basically, unless you're trying in absentia, which has other issues as well. You might also try Ukrainians for crimes committed by Ukrainian forces, but yeah, if you're only trying Ukrainians and you're not trying Russians, of course, that's quite problematic. They could be prosecuted in Russia itself, but again, until if and when Putin leaves, well, he'll leave someday, he'll die, then probably that's not going to happen in Russia for obvious reasons.
Do you have any?
Sure, I could just add 2 things. I think that my fellow panelists did really well in answering. One, I would say that I would caution against the creation of additional new ad hoc national hybrid tribunals. The whole idea behind the International Criminal Court was a single permanent institution that everyone, would sign up to, and it would be that thing. If we look at the ICTY, the criminal tribunal for the former Yugoslavia, for Rwanda, the Special Court for Sierra Leone, the Extraordinary Chambers of Cambodia, all of these ad hoc systems cost a lot of money. And it inevitably, states fund these things, but then it takes away funding from the ICC, takes funding away from the Human Rights Council. We have to remember that there's a huge amount of international architecture to promote human rights law, international accountability, responsibility, all these different things. So the purpose of the ICC was to be, let's just create one permanent, everything we send there, no more ad hocs all over the world. It's too cost effective. It's not cost effective enough. So, but now states wanting to get around jurisdictional issues related with the ICC, like, well, we'll just set up a new national tribunal. Well, who's going to pay for it? All of these kind of technical questions that are seemingly indifferent to ideas of justice. The second one is, I think that the added advantage that Ukraine has right now is that international law is the politics of international law means that it needs political will to be implemented and enforced. And if we look at 2 major conflicts in the world today, definitely Ukraine has that political will against it. If we look at the different responses from the global community, from the Israel-Hamas war and the Russia's war in Ukraine, completely separate responses, right? Not only from governments, but international corporations, civilians. This university even had a completely different response to the same. So I think the benefit that Ukraine has is that it has the political will of the international community backing it, whereas the war in Palestine, like Israel's military operations in Palestine, don't have that kind of political backing that they don't have. And we can have a huge discussion on why that is, but I think that everyone agrees that it's just there. And it's profound, from corporations to this university to governments to everything. But yeah, that's what I would add on those 2 things of.
And also not just political backing, but money. So a lot of states have made ad hoc contributions towards the investigation of the Ukraine situation. So a ton of money has flowed into the office of the prosecutor specifically in relation to Ukraine.
Yeah, like McDonald's pulls out of Russia, Coke pulls out of Russia, like, you know, but then, yeah, there's just completely different responses in the two conflicts. And so that's an added value for whatever, you know, Ukrainians might perceive as justice in the future. But as my panelists highlighted, the track record of international criminal law is very, very slow. So I think that we need to start focusing more on international human rights law. But that's just, yeah, that's my obviously bias with international human rights law, but yeah.
Okay, so thank you, everyone. I just wonder in moving quickly towards conclusion, because our time is elapsing, if the panelists wanted to provide any sort of a 30-second, either a glimmer of hope or some kind of conclusion around with respect to the limits of international humanitarian, or even 30 seconds on something that hasn't come up that you think might be part of this debate.
Sure, I would say the default legal regime is international human rights law. We need more focus and attention on the role and relevance of international human rights law in everything. Once we start moving into international humanitarian law, we have to accept things that would be impermissible under international human rights law. And then we get moving into international criminal law, and it's like jurisdictional motives and deterrence and all of these different things. I think that we really need to refocus our attention on the role and relevance and progressive interpretations, extraterritorial jurisdiction, universe of international human rights law. That's not to say that international humanitarian law has no role. It certainly does once there's an armed conflict. It categorically does. And there's a role for criminal law and there's a role for all these things. But I think what's being sidelined is the imperative, indispensable role of international human rights law. Sorry, that was more than 30 seconds.
That's okay.
Yeah, sure. Like a little bit of hope, I guess. I think we hear about violations of international humanitarian law. These are the stories we hear on the news. We don't hear about when it works. We don't hear about when armies or armed groups are following the rules. We don't hear about, you know, these everyday things that are happening. I can speak for someone that's worked in many different conflict settings around the world with different humanitarian organizations. The fact that I was able to safely work there, and we were able to construct hospitals, move medical supplies through these areas, shows that the law does work sometimes. And I think that the challenges that we've identified today are important ones, but I think the more education, the more conversation we have around these issues, the more hope we have in the future for better compliance measures.
He might be surprised, but I actually agree with what Nathan was saying as well. And I think international criminal law is inherently going to be so limited just by the nature of the jurisdictional regime, which again, a lot of people are confused about which states the ICC applies to, which it doesn't apply to. But my small ray of hope, I would actually go back to Raphael Lemkin, the Polish Jewish jurist who created the concept of genocide. And he famously wrote about having a conversation with his professor. This would have been in the 1930s, I think, studying in what is now actually Ukraine. It wasn't Ukraine at that time, but he had a conversation with his professor, and he was basically, Raphael was basically bemoaning the state of the world and how can states do this, how can they do that, and his professor said to him, he said they're like chickens in a coop, and the state is the farmer, and the state can do whatever it wants to its chickens. And of course, Raphael, that may not sound hopeful, but what makes it hopeful is that he then went on to create this concept of genocide. And even with all the mass atrocities, all the human rights violations we see today, there's more discussion than there ever has been about these issues. And I think nobody really adheres to the idea that the state can do whatever it wants to its citizens or to its chickens, to use this metaphor. So I think that actually that mentality has changed a lot, even if we note the incredibly, significant voids in terms of the application of international law.
All right, thank you. Well, in conclusion, I'd like to thank Adam Muller, who's actually responsible for sort of orchestrating and organizing this. He's the PAX director here. I'd also like to thank Jason Brennan, who's responsible for making sure that this was, for the technology and for our ability to do this today. As well, certainly, thank each of you joining us online and in the room, and certainly grateful to our speakers, Karyn Stone, Dr. Nathan Derejko and Dr. Kjell Anderson, each of which for agreeing to convene here and meet on extremely short notice, very short notice time to organize this. And we thank everyone here. You know, everybody had to make room in their lives for this, so thank everyone for their interest and for being present here today. So thank you.
Thank you for moderating.